Today we will continue with the topics in Indian polity with respect to rights which are in news in the late 2023 and 24 Jan Feb, right? So today we are going to discuss some rights as well as some important judgments which were there in the recent times. So here the news regarding all these are related to one another. But the real news which came was Supreme Court recently gave divorce to a couple under Article 142, that is exercising the powers under Article 142. So last session, we saw what is Article 142 and why it is important and how it gives powers to the Supreme Court. But Supreme Court exercised that particular extraordinary right to provide a divorce for a Hindu couple recently. And this particular judgment becomes important because it used Article 142. And also it said that Supreme Court can directly provide divorce under this using the powers of Article 142. Instead of directing the family courts, because family courts have their own procedure. So in India, we have divorce which can be awarded by the family courts. So with certain procedures established under Hindu Marriage Act. So they have to be given a minimum time of 6 months, and they should have been living separately for more than a year. So likewise, there are many criteria under which, but Supreme Court said without doing all these, so they can issue a divorce under this article. But they have provided certain guidelines. Okay, so they have provided certain guidelines when they are using Article 142 for issuing a divorce. So the most important thing is they will consider, that is the guideline in the sense, the guideline says that they will consider the duration of the parties who cohabited after marriage. So after marriage, how many years they had been, or the time period they had been cohabiting, and what was the last time they had cohabited, and what is the nature of the allegation, and what were the exchange of legal procedures or legal proceedings, what the courts have undertaken before, and what is the impact, cumulative impact, what they can have. So the status of children. So many aspects they consider. So they provide a list of guidelines, and out of the consideration of the guidelines, the separation is awarded by the Supreme Court. So this is the basic logic under which this comes in. Okay, so the very idea of this issue comes in this particular case. Okay, now whether right to divorce is a fundamental right. Anybody?
No, sir.
No. Okay. So right to divorce and similarly right to marry is not a fundamental right. Okay. So it is just a human right, which is not a fundamental right as of now in India. So similarly, right to marry is also not a fundamental right. Whereas when right to marry a person of one's choice, so that becomes a fundamental right under Article 21. So here we have clearly mentioned that that is especially Chief Justice of India, when he delivered the judgment, he clearly identified that institution, marriage as an institution, okay, then marriage as an individual right. So in this, he clearly identified that marriage as an institution, the rights are identified as fundamental, which are individual exercise of one's choice or decision, right? So those are coming under what do you call the fundamental rights, whereas the other peripheral factors, it is not a fundamental right. So right to divorce, right to marry doesn't fall under fundamental right, whereas when a person decides that a person has to marry a person's this particular person of one's choice, then that becomes a fundamental right. Similarly, right to adopt, yeah.
So right to divorce, is it a statutory right?
Yeah, it is under Hindu Marriage Act. So legally, you can have a
Maybe
right
the
to
right to
divorce.
marry also? Is it
Right
a
to
statute?
marriage, we cannot put it as statutory. It is just see, Hindu Marriage Act or any other act says that when a person wants to marry, they have to marry in this particular choice. So it is procedural. It doesn't confer you a right to marry. Right to marry means it is a right in which a person has to marry. Got it? So person has to marry as a matter of right. It's not that much enshrined as a what do you call the fundamental, or in that connotation it is not there. Okay, say legal statutes are there, no doubt about it. Say you have Hindu Marriage Act and other personal laws. So both of them, I mean both these aspects, that is right to marry and right to divorce. So as a matter of human right, yes, of course they are enshrined. Okay. Whereas right to divorce, yes, it is a legal right which is provided, especially in individual personal law. Say, for example, Hindu law or Islamic personal law. So individually they have, but right to marry is not in that particular sense, right? So because it is a collective right? So it is a person's choice. When it comes to person's choice, then it becomes fundamental. If it is not, it is not. It is just a human right kind of. Got it? So whereas right to adopt a child, again, this is another case where a couple went to Supreme Court where they were denied the right to, surrogate rights. So because of certain legal issues, they couldn't do surrogacy. So they went on for adoption, and adoption had some issues. They went to court. The court clearly identified that right to adopt a child is not a fundamental right. Okay, so again, it is not a fundamental right. So it is just a basic right. So similarly, every child has a right to family. Okay. And that particular right of a child for a family should be considered when the right to adopt a child comes into picture. Okay. So that is how the Supreme Court handled all these three forms of right to divorce, right to marry, right to adopt. All these three not a fundamental right, whereas involving person's choice, fundamental right. And similarly, right to protection of sexual orientation. So this we have already discussed in part one of the rights, where it is a fundamental right protected under Article 21, right to privacy. Right. So this is fundamental right. And similarly, recently in another judgment, we have seen right to reproductive and decisional autonomy of women. So this is a fundamental right declared by Supreme Court, especially a right to abortion, which we have discussed already, and right to fetus, especially after 24 weeks of pregnancy, right to fetus comes into um, consideration. Whereas right to abortion and right to fetus, we try to have a balance. Okay, so right to abortion is also a fundamental right for the women. Okay, under the right to reproductive and decisional autonomy. So this is how we have basic aspect what we have on part of these. So for right to abortion and right to fetus, you can refer the first part of the discussion in Indian polity rights part. So we have discussed that right to abortion as well as right to fetus. Right. Okay. Now, so these are some of the basic rights which are interlinked, which were there in news in recent times. Then comes three important judgments which were in news recently. One is D.K.Basu case against custodial torture, and various laws related to inheritance of property with respect to children, and Babita Puniya case with respect to appointment of women in permanent commission in Indian Army. Okay, so three cases are there. So what is this D.K.Basu case? So you know that custodial torture is against one's fundamental right, and that was declared in 1997. D.K.Basu case was a state of West Bengal, where Supreme Court held it clearly. Custodial violence, which includes whether rape or torture or death in police custody, it infringes Article 21 as well as Article 22, Clause 1 of the fundamental rights. So 22 Clause 1, what it says? So it gives the right of rights for the person who had been arrested, right? So they need to give the grounds of arrest. They need to give the right to be defended, and this article is also, I mean, this particular right is also violative in case of custodial violence. So this is one important case what we have with respect to this uh, fundamental, violation of fundamental rights with respect to the case. So actually, this particular case was referred recently in 2022 Gujarat police custodial violence or police violence. That case was taken up recently in 23, 24. At that time, we had this particular reference by Supreme Court with respect to this D.K.Basu case. Okay. So the second issue, that is your inheritance of property. Okay. So inheritance of property, what we have is that recently Supreme Court had said that children who are born out of wide or wideable marriage, wide or wideable marriage, have right to inherit, have right to inherit their parent share. Okay, so right to inherit parent share under the Hindu law. Okay, so in the inheritance law. So naturally, the Hindu inheritance law, it's just based on the Mitakshara law, what you know. So this is what the news which we had. So what is this particular uh, what we call the wideable and wide marriage? Wide marriage means from the beginning of the marriage itself, it is not recognized by the law. Okay, that means that particular relationship is not aware to this particular what do you call uh, law. Law wise, legally, it is not visible. Whereas wideable means it is a marriage which is valid, okay, which is valid, but the marriage procedure may have certain defects or certain issues where it can be nullified or annulled in future, okay, by the particular individuals. Okay, that we call it as voidable marriage. So, which has a possibility of declaring or annulled or declared void or annulled. Okay, that we call it as voidable marriage. So, whatever may be the condition, the inheritance is possible. Okay, so this is the logic. So, this particular judgment is important because it lays the foundation for the right to inherit of such children, right? Fine. So uh, in this particular judgment, Supreme Court clearly gave certain guidelines. So how to determine the share, the inheritance share. Okay. So here you need to remember that we have two important words: succession, inheritance. Okay. What is the difference between succession and inheritance in property? Hmm? Succession or inheritance. Hmm. So succession is through a will. Okay. So written will. Inheritance by a matter of the legality. Okay. So in case if a person doesn't have any will and he dies and he has some property, how the property will be distributed? Through the law of inheritance. If the will is there, the person has a will, and that particular will is to be executed, then that we call it as succession, because according to the will, it will be provided. Got it? So this is the logic how these two words are operated. Fine. So this is basically important, and you know that equal inheritance rights are provided. Okay, so recently also we had a judgment with respect to that. And similarly, in 2022 also there was a judgment where children due to live-in relationship, so their legality has also been established. So children bond to partners who are in live-in relationship are considered as legitimate. Okay. But the thing is that live-in relation should be for a particular period of a longer term. So it should appear to be a longer term. It's not like walk in, walk out. Okay. So it should be a longer term. So anyway, that particular long term is not defined, but it appears that when the relationship is continuing for a considerably a longer time, where it can be said that the couple have been living for a considerable years, so then we can term it as legal, right? So that is the inheritance will be legally accepted. Okay. So similarly, daughter can also equally inherit. That also, you know, that in 2020 as well as 2022 we had similar laws which were providing the uh, inheritance right to daughters and sons equally, especially in the ancestral property, right? So that is the reason why a couple of years before you had Mitakshara versus Dayabaga, the question which was accepted in, asked in your prelims, right? So this is the second part. Whereas the third part is the Babita Puniya case in 2020. So here, the Supreme Court identified that the women officers who are in short-term service, okay, so short service commission, so they are equally eligible for permanent commission like men. It is the basic judgment, and whether they have completed 14 years or 20 years of service, irrespective of it. So whether irrespective of their services, what they have completed. So the female officers are eligible for appointment in the permanent commission, right? So this applies to all the three defense forces, that is your Army, Navy, and Air Force, including your Coast Guard. Okay. So in all services. So this is again in news because in recent times, this Coast Guard, actually this particular reiteration of the judgment came with Coast Guard, where the Coast Guard's admission to the women were delayed. So the Supreme Court again came down on Coast Guards to open up the permanent commissions for, appointment of female officers. So these are some of the important issues which we have in this particular regard. Clear? So these cases, especially the inheritance, which were continuously in use for past 3 years, and this particular Babita Puniya case, which they said, so Supreme Court clearly identified it. What is Article 33? What is Article 33? So it is exemption of fundamental rights with respect to military. Okay. So in fundamental rights chapter, you can see there will be some exemptions with respect to military. So that is under Article 33. So 15, 14, and 16 are violative in case of non-appointment of women. So that is what the Supreme Court held, though there are certain exemptions which were claimed in 33. Okay. Till then, defense forces said they used this particular article to have this particular differences, but Supreme Court said it cannot happen. Okay. And similarly, custodial torture. And remember, you have UN Convention on Custodial Torture. So try to have a look upon it and India's status towards the custodial torture. And especially in Article 21, the implied rights, you can say right against custodial torture. So implied right, it is not a fundamental right, it is an implied, but the rights related to it is Article 21 and 22 clause 1. So all these you try to have consideration. Okay, so these are some of the rights and articles which are there throughout. Okay, so when you refer to the previous first video in this particular series, you can understand the total articles which are in news and as well as rights in news in these time period. Okay, thank you.